Welcome back. So we've been talking about non-competition agreements, and we've been focusing on the idea of enforcement. We're only going to enforce certain non-competition agreements. So how do we decide which agreements we will enforce and which we won't? Well, the first thing you have to understand is that enforcement of a non-competition agreement is a matter of state law. There is no federal law of non-competition agreements. There's simply no federal law that applies to non-competition agreements. Every state has its own laws, which for you as future employers can be difficult, because that means you're not working with one coherent set of laws. You are working with 50 different laws. And the fact is that state law differs greatly in how it treats non-competition agreements. Some states enforce virtually all reasonable non-compete agreements. Now, I say they'll enforce reasonable non-compete agreements. No state will enforce an unreasonable agreement. However, if the agreement is reasonable, some states, maybe even many states, will enforce that agreement. So states like Arizona or Texas or now Georgia, they will enforce all reasonable non-compete agreements, meaning they do the analysis, is it reasonable or not, the two-part analysis of reasonability, and if so, then they enforce it. Some states refuse to enforce non-competition agreements. For instance, California. California is famous for having a restriction that says no employer can prohibit an employee from moving to a different job. So in California, the only non-competition agreements that are enforceable are those in conjunction with the sale of a business. So that means no California court is going to enforce a non-competition agreement. Even if the non-competition agreement was legal or reasonable in the state where it was executed, in California, it's not going to be enforced. And then, of course, some states utilize what's called the blue pencil doctrine. And this is an area I've spent a lot of time looking at and studying. The blue pencil doctrine says that if a non-competition agreement is unreasonable, the court can change the agreement so as to make it reasonable. Now you can imagine that this is kind of an odd idea, that if you and I enter into an agreement and it sets out certain restrictions, and maybe the restrictions are such that they would be unreasonable, the fact is the document we executed doesn't really mean anything until a court looks at it and says, I'm going to modify that. So we call this the blue pencil doctrine. Sometimes it's called the equitable modification doctrine. And again, I've got some articles posted on this blue pencil doctrine for you to scan and look at, because of course it's controversial, and there's a strong argument for abandoning the blue pencil doctrine, which is to say that employers should be encouraged to enter into reasonable agreements. That means an employer has to think beforehand, is 5 years too long for this job? Well, if it is, if most people would say it is, then the employer has an incentive to lower that, because if it's not reasonable, if it's too long, then they don't get to enforce the agreement. But in a state that uses the blue pencil, what does that mean? That means that the state, the employer, is free to execute an agreement that says 5 years, and you, the employee, may think that agreement is 5 years. The employer has nothing to lose by stretching the restriction, because they know that if you wind up leaving and I sue you in court, at most what the court will do is lower the restriction to 2 years, to what it should have been in the first place. And so the blue pencil doctrine ignores the writings between the employer and the employee and instead focuses on what's fair, what's equitable. Whenever you hear the word equitable, they're referring to ideas of fairness. So this can be problematic. This can be problematic because it encourages employers to draft unreasonable agreements. There is what we call in the law the in terrorem effect. That's a Latin phrase meaning even though the agreement's not reasonable, it can terrorize you as an employee to not do that which you want to do, which is to leave and work for a competitor. So it's going to restrict people from moving, from changing jobs, even though it's not an enforceable agreement. So the in terrorem effect is enhanced through the use of the blue pencil doctrine. Because I don't know, is it 5 years? Is it 3 years? Is it 2 years? Well, if I don't know, maybe I just stay at my same job. Maybe I just keep doing the same thing. And of course, this is problematic for society as well, because when you're an employer and you can't hire someone who's qualified and ready and willing to do the job, that means you've lost a very good employee. You may have to find someone who's not as good of an employee. You may have to go out and find someone else, and that's bad for employment. Now, there is a case that, again, that I've uploaded on it, and I put it here in large part because it really discusses the blue pencil doctrine, the valid criticisms of that. And this is a case out of Nevada that came out in 2016. And this case concerned a woman who worked for a casino. And when the woman, before the woman left, she actually downloaded some trade lists, some customer lists, and took them to a new job. And when the previous employer found out that she had taken this customer list, they sued her on the non-competition agreement that she signed. So yeah, there's a basis for stopping her from doing what she was doing, but instead they simply relied on the non-competition agreement. And what the non-competition agreement said was that this person is prohibited from working for any casino anywhere in the world for a certain period of time. And the court said that's too long, that's not reasonable. And so then the employer, the casino, argues to the court, use the blue pencil doctrine. Change it. Restrict it to Nevada, or restrict it to Reno and Las Vegas. Restrict it to just Reno. Use the blue pencil doctrine to come in and fix this mistake. And the court said, we're not going to do that. We want to encourage employers to enter into valid, enforceable agreements, and therefore we are not going to change this agreement so as to make it reasonable. Because when you use the blue pencil doctrine, what you're really doing is creating a situation in which the court is drafting the agreement that the parties should have agreed to originally. So state law differs greatly in how it treats non-compete agreements. Now, if there is a trend, and this is something important you should know for your tests, in those states that enforce non-competition agreements, it's much more likely that the agreement will be enforced. We are sort of in a time period right now in which state legislatures and state courts are trying to create a business-friendly environment. And the belief is that if we permit these non-compete agreements, if we permit broad non-compete agreements, then in fact that's good for businesses. And we want businesses to move to our state and hire people in our state. And so we've seen a trend in which more non-compete agreements are being enforced than were 10, 20 years ago. One of the ways in which they have relaxed restrictions is that legitimate business purposes have been broadened. We know these have traditionally been goodwill of the business and trade secrets, But in some states, courts have found that just making more money is a legitimate business purpose. You will do better financially if you restrict this employee than if you didn't. And therefore, that's a legitimate business purpose. So we've seen that in a number of states. We've seen them broaden the scope of activities that may be restricted by non-compete agreements. And that no longer are we getting the situation where if someone is an engineer at one firm and goes to work in the marketing department of another firm, courts are more likely to say some of that knowledge is going to seep into the new position, and therefore we are going to prevent this person from moving into that very different position. So courts have broadened the scope of activities. We've also seen a number of states enact statutes that make it easier to enforce non-compete agreements. And the best example of that is in Nevada, which is just last year, Nevada, the state of Nevada, passed a law overruling that Golden Motor Road decision and saying that now courts are required to use the blue pencil doctrine. It's no longer a matter of at their discretion. Instead, the state statute says a court must use the blue pencil doctrine. A court must fix the mistake of the employer to change what it is that the employer originally required them to do. And so now the blue pencil doctrine is in some states, certainly in Nevada, you must fix the effort. We've seen this also in Mississippi, Arkansas, and in fact, Texas was one of the pioneers of this, requiring courts to fix broken non-compete agreements, unenforceable. We've also seen the use of a step-down provision. What the step-down provision is that sometimes in an agreement, the restrictions will be reduced inside the agreement. So it'll say this person is restricted from working for 5 years nationwide at any position. And then they'll have a second subclause that says if a court finds this restriction unenforceable, then this person is restricted from working for 2 years in this 3-state area doing sales work. And then they'll put another one. If a court finds this provision unreasonable, then the person is restricted from working for 6 months in a 1-state area in this particular job. And so what it does is it builds in uncertainty to the agreement. So now the parties don't know what is the non-compete agreement. But it allows courts to go back and just cross out, using the blue pencil, the editing pencil, those previous provisions and choosing the provision that they believe is reasonable. So technically permissible, and technically these are terms that the parties have agreed to, but not really. So the step-down provision, however, is definitely enforceable in a number of states.